violation of prospectus under the Companies Act, and SEBI has no jurisdiction. Only Ministry of Company Affairs has jurisdiction, not SEBI. That was discussed in detail by the Honorable Supreme Court and said, if it is a matter relating to the market, though it can be sections 55 and 65 and 67 of the Companies Act 1956, if it is a matter regarding market, public instruments, public shares, etc., then SEBI has the jurisdiction. So SEBI has they said, addressed to Bombay Stock Exchange, National Stock Exchange and other exchanges, that in the futures and options market, nobody can cross 1%, nobody can cross 5%. There's the position limit and the exposure limit. The NSE in turn issued its own circular following SEBI circular. Now, Lordship's question is, suppose I violate the SCRA. What is the consequence? And can I still punish him?
Whether breach of any of the regulations of securities contracts by itself attracts fraud?
Yes. No, it doesn't attract. It may not attract fraud. It may not. Exactly what has happened is this. In fact, out of the 12 entities, except one, all kept within the limits. The very idea of having 12 is each one doesn't cross 1%. That was the whole idea. One of the entities crossed 1%. And National Stock Exchange has imposed a penalty of 1 lakh on that exchange. What SEBI is saying is the conglomeration or the aggregation of all this together is amounts of fraudulent practice under the SEBI regulations.
So therefore you are inferring fraud on the basis of the breach of the regulations.
Breach of the FUTP regulations. Breach of the FUTP regulation. Now, my lord, the point is this. Fraud can take place in very many ways. Basically, fraud, I'll take the definition. That's part of my statutory provisions. Fraud is defined in section 21C, regulation 21C. What is fraud? Regulation 3, regulation 4. There are statutory provisions of SEBI. One of the methods of committing fraud is to have a colorable device where you do indirectly what you can't do directly. As in our case, in this case, we say you have started these 12 companies with the whole sole purpose of committing fraud. And that falls within the definition. And our point is, these 12 companies, as I mentioned, are all done by one person. What's his name? Avinash? Yeah. Sandeep Agarwal. I was about to take your lordship to the agreement. The agreement with Reliance says all the 12 companies will act on the instructions of Reliance, and whatever profits are earned by these 12 companies will go to the benefit of Reliance. They say so in so many words. All that has come later. So to answer your lordship's question, SCRA doesn't define fraud. The fraud comes under the FUTP regulations, which are drafted in terms of section 11 and 11B of the SEBI Act. So
what is the penalty imposed for the breach of this securities?
1 lakh. On one company they have imposed. Because only one company violated the limit.
Out of 12?
Yes. And they imposed 1 lakh. What the minority view, what Mr. Salve was stressing upon the minority view was, what the minority decision has taken in SAT is, if I violate the position limits, I can only be punished for the position limits. I can't be punished under FUTP.
That's
at page 20.
Your argument is that it attracts PU,
yes.
PFUTP also.
Yes.
Now, supposing, just for the sake of this one company would also not have committed this breach, then what would have been the position?
Then only PFUTP. Suppose this one company had not crossed 1 lakh. But 12 companies together cross 1 lakh. So we are saying basically lift the corporate wheel. What are these 12 companies? That's the English concept of single economic unit.
So SCRA is governed by the exchange.
Yes. But ultimately, what is fraud? You have got 12 companies, all purport to act within the 1% limit. So nobody knows what is happening. Everything is under a cloud. And we also came to know only after investigation that there were 12 companies. There is one Sandeep Agarwal. There is all this we came to know only later. Yeah, we came to know later. Now, SCRA, now let's get this structure of the market. There is an overarching regulator, SEBI, which we control shares, mutual funds, options, everything SEBI controls, the entire market. There is SERA Act, which basically governs the stock exchanges. So all the old stock, now of course, because of online trading, the old things have gone, because there used to be Madras Stock Exchange, Calcutta Stock Exchange, Coimbatore Stock Exchange. Physical trading would take place on the floor of the house and all that. All those things are not there now anymore. So all these exchanges were formed under SERA Act. Now, as far as SERA Act is concerned, Lordship mentioned Section 9. Section 9 applies only to members, doesn't apply to these 12 companies. It says if a member violates a bylaw, because Lordship will kindly see, member is actually a broker. Member means who's a member of the stock exchange. He has a card, membership card. Only he can do the trade on behalf of somebody else. Now, these 12 companies are not members of the stock exchange. You've got a member, then you've got a clearing member, all those things are there. So what SCRA Section 9 says is, violation of a member attracts certain penalties, expulsion. Now, obviously, I can't expel these 12 companies because they're not members. So 9 applies to members. I'll read that section. 18A talks of derivatives. And they say derivatives must be carried out in accordance with the rules and bylaws. Now, the bylaw of the stock exchange is nothing but the bylaw of the SEBI. SEBI tells who has fixed 1%. It's not in the act. But SEBI said to avoid monopoly position, to avoid any person taking a dominant place in the market and trying to manipulate it, nobody can cross 1% in terms of the limit. In terms of the exposure, 5% cannot be. Nobody can be exposed to more than 5% of the available stock in the market. That is the rule. So to answer your Lordship's question, violation of SCRA attracts a penalty of 1 lakh for crossing the position limits. That is imposed by the exchange. Only one of the 12 companies crossed the limit of 1% and they were visited the penalty of 1 lakh. Now, what SEBI has done is issued notice under the PFUTP. That is a fraudulent practice. The Lordship has to decide whether starting 12 companies with one person like this.
So this is what we want to understand.
Yeah, yes.
Creation of 12 companies.
Yes.
According to you, attracts PFUTP.
Yes.
But even if all 12 companies were within the limits,
It will still be a fraud.
that is your argument.
It will still be a fraud. Otherwise, the position limits are meaningless. No? Lordship may appreciate if I have a 1% limit.
Those 12 are not independent entities.
Not entities.
That's what you are.
Yes. And they're starting for this purpose. I'll just take a Lordship to the clause. Please see the clauses, my Lord. My Lord, as your Lordship rightly put it, if all the 12 companies are at arm's length, they're independent entities, they're independent, nobody bothers. Because there are thousands of people in the market. And what was the fraud was?
Which clause you?
Yeah, 1.2 and 1.3.
591, volume 3.
Volume 3, page 591.
Which will be the page?
Volume 3, page 591. What's the PDF page? PDF page. I'll just log you lots of the PDF page in a minute.
169.
One-
PDF 169.
No, PDF 169.
PDF 169.
Yes.
And internal page?
Internal page 591.
No, then your PDF doesn't match.
Volume
Your Lordship has got volume 3
volume
of the additional volumes.
604.
appeal volume 3.
604.
No, sir.
Got it.
Lordship has got it.
My Lord, is it page 591? Am I? Is
591.
and page 169. I am reading from the whole time members order, and the whole time member has extracted the relevant agreement.
The relevant clauses of the agency.
Yeah. May I read the Lordship permission from page 590,
Just
4A.3. All the 12 companies are in the
Just-
tabular
just-
statement. Yes, sorry.
you are reading page 591.
My Lord's kind permission, can I start at page 587?
Huh,
These are the 12 companies he has given the,
I got it.
yeah. And Lordship will note all accounts are opened in around the time.
Huh.
And Lordship will kindly see, first is client name,
Hmm.
and this is the trading member name.
Hmm.
This is who's the member of the stock exchange. Because you have to trade only through the member.
Hmm.
So there's a trading member. Now they opened the account on 1/11/2007. Lordship knows 29th November was the last date.
Hmm.
Date of agreement, etc. Date of first trade. So there are 12 companies which go on till page 590. And now please come to 4.8.3. May I read, Manoj?
4.3. Huh.
I'm trying to show how did the whole time member arrive at fraud. Yes. The table above shows that 11 entities except Dharti had opened new trading accounts with different trading members during the period May to November 2007.
Hmm.
Dharti had its account opened in 2005-2006 through different trading members. Each of the 12 entities entered into separate agreements with noticee number 1. That is Reliance Industries. It's RIL. Between 30/10/2007 to 3/11/2007.
Hmm.
A few of the notices, such as so-and-so, so-and-so, these are out of the 11 companies, had never traded in the F&O segment, futures and options segment, between April 1 to November 2007, before they entered into agreements with noticee number 1. The above 6 entities traded in RPL futures for the first time on 1st, 5th and 6th of November 2007. The agency agreement also envisaged that the transfer of profits arising out of the F&O transactions would be made over to the account of noticee number 1 by the agents, and that they would earn commission for these services. The relevant clause, now this 1.2 and 3.2 are important. Let's see 1.2. All investments will be made by the agent based on the prior instructions of the principal. In case the agent recommends any proposal, the agent shall execute the transactions only after the proposal has been evaluated and approved by the principal and investment instructions are communicated. Sale of investment will be done by the agent only based on prior instructions of the principal. So principal is RIL and agent is each of the 12 companies. So this is standard agency agreement. Now please come to 3.2. During the course of executing transactions, the agent is permitted to execute transaction in its own name. It is, however, understood that all such transactions will be done by the agent for and on behalf of the principal, and all profits and losses arising out of such transactions shall be to the account of the principal. But I cannot imagine a more blatant violation of the position limits and the SEBI circulars and the PFUTP regulations. You are supposed to trade independently. You can't appoint agents who will act on behalf of the principal, and then you say the profits, and this all has come to light later, these agreements. So now this violation comes under the PFUTP because this amounts to fraud according to. Now please see next paragraph. In terms of letters of notices 2 to 13, one Sandeep Agarwal was commonly authorized by them to place orders on behalf of them in the F&O segment. As stated earlier in this order, Sandeep Agarwal was an employee of a wholly owned subsidiary of noticee number 1 Reliance. The details of the agent's email ID and other connection directors as shown in table is extracted under. Now all the addresses are given. So what I'm submitting is the whole time member has made a detailed investigation into the entities, what are their origins, what is their share capital, when did they start, what is the agreement. This is the entire factual situation which is entered into. And why I'm belaboring on this is this. The SAT by majority has approved this. Interestingly, the minority view accepts the factual position that there is a violation. But they say the violation consequence is only a penalty under the SCRA and not under PFUTP.
So that is one aspect we'll have
So
to
by
take care of.
3-0, the finding of violation is affirmed. So that makes our task slightly easier because on facts, there is no confusion that there is a violation. But what the member says, which is, if your lordship takes Mr. Salve's submissions, the summary can be put at page 20. Question number C. That is the crux of the whole argument.
Yes.
Yes. My lord, it's page 20 C. May I read, my lord?
Yes.
Both your lordships have got it. Where the violation of the SCRA circular can be visited with a punishment under PFUTP regulation in the SEBI Act merely because SEBI is the administering authority for both the acts. The majority judgment held. It is an established fact that SEBI administers the SCRA 1956, the SEBI Act 1992, Depositories Act 1996, and delegated provisions of Companies Act 1956/2013. Therefore, if the nature of the violation specified in any legislation spills over to the mandate under another legislation, SEBI is fully within its right to invoke the provisions of both/all these legislations. This was settled in the Sahara case, where the argument was the violation of prospectus under the Companies Act, and SEBI has no jurisdiction. Only Ministry of Company Affairs has jurisdiction, not SEBI. That was discussed in detail by the Honorable Supreme Court and said, if it is a matter relating to the market, though it can be sections 55 and 65 and 67 of the Companies Act 1956, if it is a matter regarding market, public instruments, public shares, etc., then SEBI has the jurisdiction. So SEBI has jurisdiction even under certain provisions of the Companies Act where it deals with the market, like prospectus, shares, public issue, IPOs, all that comes under SEBI. Now, this is what Mr. Salve's argument is, and this is what the crux of the argument is. On the other hand, minority judgment held, if a person violates any provisions of the SCRA Act, the provisions of SEBI will not automatically come into play. Even if there is a violation of the position limits, it cannot attract provisions of 3B of the PFUT regulations, which have been framed under the SEBI Act. The SCR prescribes penalties separately for violation of the position limits. Thus, Regulation 3B is not applicable for violation of position limits. Now, if this minority view is sustained by the court, then what will happen is you can have the position limit becomes meaningless. Any person can dominate the market by having 20, 30, 40 companies, have an agency agreement, and say that whatever profits you make will come to this. Basically, what is the respondent number appellate doing here? He's employed 12 people to take a short position, knowing that when he's going to sell 22 crore shares, the market is going to fall down. If the market is going to fall down, all these companies who have taken short position will make. But when you say short means the market is going down, when you take long position means you expect a bull run, you expect a market to go up. So I take short position, knowing fully well that when I offload 22 crore shares, demand supply, my lord. Suppose tomorrow suddenly 10 lakh shares of Infosys is put in the market price will come down. Demand and supply. Same way, my lord, this is what they have done. So our humble submission is, if this view is accepted, then what happens is I can violate the position limits. I'll pay 1 lakh fine. And if I don't violate the position limit, I won't pay that also.
Okay.
And what is the gain made by these 12 companies and passed on to this thing? 513 crores. And what does the member, whole-time member do? He says out of that one member, so 513 is made by 12 companies. So about 40, 45 crores per company is the profit. The whole-time member is fair enough to say that, look, one company we have penalized. So to the extent of 45 crores, don't disgorge. You disgorge the remaining 45. SEBI appellate tribunal says, no, that is wrong. You can't spare him disgorgement. Because if he has violated the thing and committed fraud, disgorgement is the answer which goes to investor fund. I can also impose a fine and a penalty which goes to consolidated fund. I can do both. But the SAT says, since SEBI has not filed an appeal on that, we are not disturbing that order. SEBI notes, SAT majority notes that this question of penalty is not a ground to drop the 44 crores. And we are also not disputing it now. Now the matter has gone. 447 crores is the amount to be disgorged. I think they have deposited 250 crores so far. Right? By the impugned interim order of the Supreme Court, they have deposited 250 crores.
Okay.
Now, my lord, so my humble submission, facts your lordship knows. With the lordship permission, let's go to the regulations. And shall I go to the SCRA regulation, lordship asked section 9 and section 18A? Then I'll tell lordship what I'm going to do. I'll just read those two sections, won't take much time. Then I take a lordship to the circular of SEBI, which is followed by SCRA. And then I'll take a lordship to PFUTP regulations and two judgments. Because one of the arguments taken was, I never induced anybody. I am trading on my own. I never induced anybody. That is answered by Rakhi trading by the Honorable Supreme Court. They said in a market where the buyers and sellers are unknown, everything is on system-based, computer-based trading, screen-based trading. Supreme Court said, once there is evidence of manipulation of the market, then inducement is presumed. That's the thing. Otherwise, it will be impossible for SEBI to say, I'll have to identify who is the person induced. In a market dealing with 22 crore shares, it's not possible. So Supreme Court has taken a purposive interpretation and said, once I prove manipulation, once I prove fraud, inducement can be presumed. I'll come to that. Now, lordship will first take, since your lordship started with section 9 and 18, please see section 9, please see section 18A, and I'll go further.
Act कीजिए, securities.
It's in volume 2, my lord. All the provisions are in volume 2. So they got the act all. Section 9. Your lordship, since your lordship is in the act, it's better to start. Just see the preamble, so lordship will get an idea of what this act is for.
Yes.
Lordship will just immediately notice that the Companies Act came in 56. And this also was drafted in 56.
Right.
And please see the preamble. An act to prevent undesirable transactions in securities by regulating the business of dealing by providing for certain other matters connected therewith. And they have dropped by prohibiting options. And I may just tell your lordship that before the SEBI Act came in 1992, all these public issues, etc., were controlled by the ministry under the, but there's a control of capital issues. That is gone now, and SEBI has taken over. Now, please come to section 9. First, please come to 2(1)(c) member. 2C. Member means a member of a recognized stock exchange. Then, please come to section 9. Lordship will just see recognized stock exchange at page 370, section 3.
Yes.
Any stock exchange which is desirous of being recognized for the purpose of this act may make an application prescribed by the central government. So then 4 is granting recognition to stock exchanges. And Lordship will come to section 9. Lordship will note, not here, it has taken place in Bombay Stock Exchange and National Stock Exchange. 9. A power of recognized stock exchanges to make bylaws. Any recognized stock exchange may, subject to the previous approval of the Securities and Exchange Board of India, kindly note, my lord, may subject to previous approval of Securities, and that has been substituted for central government. Lordship sees, my lord, earlier it was central government, now it is SEBI. Make bylaws for regulation and control of contracts. In particular, Lordship now comes to Regulation 3. So, no, one second. 2 provides for bylaws, what all bylaws can provide for, and 3 provides for what the bylaws can. The bylaws made under this section specify the bylaws, the contravention of which shall make a contract entered into otherwise in accordance with the bylaws void under section 1 of section 14. Provide that contravention of any bylaws of the shall render the member liable to one or more following punishment, namely fine, expulsion, suspension, any other penalty of a like nature. So what is 9(3)(b) is quay the member, who is that second column in that chart. One is the client, the trading member. So now come to 18A. Notwithstanding anything contained in any other law for the time being in force, contracts and derivatives shall be legal and valid if such contracts are traded on a recognized stock exchange, settled on the clearing house of the recognized stock exchange in accordance with the rules and bylaws of such stock exchange. That non-obstante clause is to avoid confusion about wager, etc., etc. So these derivatives are taken. So these are the two provisions. Now let us go to the circular on the position limit. So these are the two provisions of SCRA. Other provisions may not be relevant. If my lord is now, I have to go to the circular on the position limits. Please take the position limits. First circular is in volume 3, PDF page 22 and running page 444. Volume 3, my lord. Appeal volume 3. Page 22 PDF and running page 444. It starts with circular November 2, 2001. Is it tallying? You know? Yeah. My lord.
Which page you say?
444.
Annexure A2.
Annexure A2.
Yes.
Now, this letter or circular is issued by the Chief General Manager of SEBI Derivative Cell. And please see its address to whom? Addressed to the Chief Executive Officer / Managing Director of Derivative Segments of NSE and BSE and their clearing houses / corporations. Dear Sir, scheme for introduction of single stock futures and risk containment measures. Then Lordship will kindly see. Yes. Now there was an advisory committee set up and then it comes to, yes. Please come to the page 445 at the bottom. Last paragraph. The scheme of introduction and risk containment measures for single stock futures contract framed in consultation stock exchange within the framework of the advisory committee on derivatives and approved by the SEBI board are as follows. Then, my lord, it goes on and Lordship will now come to page 4-5. That's what I'm going to 4-5. Yeah.
453 is position limits.
Where?
Position limits.
Yes, position 4-5. Yes. I'm coming to it. Position limits. This whole case is violation of position limits. On the introduction of index futures contracts, index options contracts, and stock options contracts, the trading member level and the market-wide position limits were prescribed. However, with the introduction of single stock exchange contracts, a customer level position is prescribed. It's very important. Earlier it was limits qua the member. Now what they say is, since you got single stock, not earlier what is to have, they should not have single stock futures. They'll have futures of a group of stocks like NSE 50, index future, NSE 50, BSE 50. There'll be a stock of a group. Now what they said, you can have futures in Tata Steel, Reliance, TVS. You can have stocks of any individual company, Pfizer, Glaxo, whatever it is. So they are called single stock futures. In this case, the single stock future was on Reliance Petrochemicals. With the introduction of single stock futures, a customer level position is prescribed to, now this is very, very important, to deter and detect concentration of position and market manipulation. The purpose of position limits is to create a deterrence against concentration and market manipulation. The market-wide position in the case of stock-specific derivative contracts, both stock option and single stock futures, shall be applicable on the cumulative open position in derivative contracts on that stock at an exchange. the volumes in derivative markets are growing steadily, and therefore position limits shall be reviewed by the advisory committee on derivatives from time to time, and the advisory committee shall be empowered to weed out any operational issue in the imposition of position limits. Client/customer level position. The gross open position across all derivative contracts on a particular underlying of a customer client should not exceed the higher of 1% free float market capitalization in terms of number of shares, or 5% of the open interest in the derivative contract on a particular underlying stock. The Lordship will just make a note, if my Lord doesn't mind. 1% in the case of RPL came to 1.01 crores. And actually what was done was 9.92 crores. The limit as per law is 1.01 per client, thing. And all put together came to 9.92. 5% open interest in the derivative contract on the particular underlying stock. Now, if the Lordship takes 5% on 6/11/2007, 62% was the max. 5% was 62%. Sorry, 5% was the maximum. Actual position of all the 12 companies came to 62%. So I'm saying it's not a marginal violation. It's gone 5, gone to 6, 7, like a de minimis rule, it doesn't matter, it's a violation. Here you're gone 12x, 62% your cost. And on 29th of November, that last day when that last 30 minutes, which is hammered the price, was 93%.
Okay.
That's why we request my lord to uphold the order of SAT, because it's a clear case of fraud. Now, kindly see, this position limit would be applicable on the combined position in all derivative contracts on an underlying stock at an exchange. At present, the trading stream, etc., etc. Yes. Now, this is the SEBI circular. Now, what is the circular issued by the stock exchange? Which is at page 460.
Yes.
And Lordship will kindly see, our circular is 2nd November. Their circular is 7th November. And they open by saying, SEBI has informed Exchange Clearing Corporation by circular dated 2nd regarding risk containment measures. And they in turn apply the same limits. So what I'm trying to mean, the position limits are at page F, at page 470.
Yes.
And at 471, 1%, 5%. Yes. So what is this stock exchange circular? Is not a circular dehorse what SEBI has said. SEBI has, this is what Lordship, this is what's called giving effect to circulars. Lordship knows, my lord, in customs and foreign trade policy, the Commerce Ministry says solar panels will be exempt from duty. That's an announcement by the Commerce Ministry. The Customs gives a giving effect to notification under section 25, saying that in excess of powers under 25, solar panels are exempt. So the policy is announced by Commerce Ministry. Giving effect is done by the custom, because there has to be a parallel. So now, to apply to the exchange also, though SEBI is enough, but this is doubly made sure that exchange also informs all its members, constituents, that this is the limit. So you have violated not only exchange, you have violated the SEBI limit itself. Now, we are submitting why fraud. So these are the two positions. I've shown SCRA, I've shown the position circulars. Now I take a lordship to the PFUTP circular. Which penalty 1 lakh. It's 1 lakh. But penalty is 1 lakh. Now please come to PFUTP. No. That will come as a consequence. All right. My colleagues want me to show SEBI Act first. Please take the SEBI Act. Whatever you want.
Yes.
Section 11 is very important. Lordship has got 11 now?
Yes.
Yes. 11 is, yeah. Functions of the board. Subject to provisions of the Act, it shall be the duty of the board to protect the interests of the investors in securities and to promote and development of and to regulate the market by such measures as it thinks fit. Without prejudice to the generality of provisions, the measures referred to therein may provide for regulating, etc., etc., etc. Lord, I may point out that under the SEBI Act, the rules are framed by central government. All the regulations are by SEBI. So SEBI has got mutual fund regulations, fraud regulations, derivative regulations, so many regulations are there. This listing regulation is there. Lordship knows, my lord, suppose I want to sell more than 5%, I have to make an open offer. So that all those regulations are there. Now, please come to 11 2A, 11 subsection 2A. Regulating business in stock exchange and other securities market, which includes futures and options. And please come to E, 11 2E, E for English.
Yes.
Prohibiting fraudulent and unfair trade practices relating to securities market. There your lordship gets the acronym PFUTP, Prohibition of Fraudulent and Unfair Trade Practices. That is PFUTP.
Okay.
Now please come to section 11, capital B. Power to issue directions. Save as otherwise provided in section 11, after making or causing to be made an inquiry, the board is satisfied it is necessary in the interest of investors for orderly development of securities market, etc., etc. So they've got various directions they can use. Now kindly see what is the explanation. For the removal of doubts, it is hereby declared that the power to issue directions under this section shall include and shall always be deemed to have included the power to direct any person who made profit or averted loss by indulging in any transaction or activity in contravention of provisions of the Act or regulations made under to discharge an amount equivalent to the wrongful gain made or loss averted by such contravention. But a person can make money and he can also avoid loss. Because if he's by, like say for example, this what you call unfair trade practice includes insider trading. Suppose I know the market is going to think, I sell my shares quickly. Taking advantage of my inside information, I know the share is going to fall, market is going to fall. I have averted the loss. So my share of 45 rupees I sold today, tomorrow market has come to 35 rupees. The 10 rupees loss which I averted, I have to pay back to the fund. So I can either make a gain or I can avoid a loss. Either which way I am the beneficiary. I have to pass it on to the, it's basically restitution. I can't be unjustly enriched.
Right.
So now, here what disgorgement is because of violation of PFUTP. Because yeah, lordship will also see section 12A, my lord. 12A. Yes. One second. Lordship will kindly read chapter 5A and
Yes.
please see the chapter heading, Prohibition of Manipulative and Deceptive Devices, Insider Trading and Substantial Acquisition of Securities or Control. So insider trading and substantial acquisition.
Manipulative and deceptive devices.
Manipulative and deceptive devices. Lordship will make a note of manipulative and deceptive devices. Now kindly see 12A. No person shall directly or indirectly come to B, my lord, employ any device, scheme or artifice to defraud in connection with issue or dealing in securities which are listed or proposed to be listed on a recognized stock exchange. C, engage in any practice, any act, practice, course of business which operates or would operate as a fraud or deceit upon any person in connection with the issue, dealing in securities which are listed or proposed to be listed on a recognized stock exchange in contravention of provisions of this Act or regulations made thereunder.
A also can be read.
A also, use or employ in connection with issue purchase or sale of securities listed or proposed to be listed on recognized stock exchange, any manipulative, any manipulative or deceptive device or contrivance in contravention of provisions of this act or the rules or regulations made thereunder. So our submission is forming these 12 companies in this manner, I don't want to repeat, it amounts to a manipulative or deceptive practice. Now, how does it come under the PFUTP regulation? We'll have to see what's the definition and how it comes. Now, so my lord, I've shown your lordship SCRA, shown the position limit circular, shown the provisions of the SEBI Act. Now I'll take your lordship to the PFUTP regulation. Volume 2, lordship will come to page 408. Yeah.
408.
Yes.
Yes.
One. Yes. Yes, 2C, 21C.
Yes.
Fraud. Please note, fraud includes any act, expression, omission, concealment committed whether in a deceitful manner or not. So it need not be deceitful or not by a person or by any other person with his connivance or by his agent while dealing in securities in order to induce another person or his agent to deal in securities, whether or not any wrongful gain, whether or not there is any wrongful gain or avoidance of any loss. So, my lord, what they say is once you commit fraud, you can't say that I did not make any money, so I'm exonerated. No, once you commit a fraud, irrespective of what money you get, you'll have to. What will happen is you'll be punished, but there'll be no disgorgement because you're not made any money out of it. Then, and shall also include. So, first is fraud includes all these things, and shall also include. Now, please note, Lord, a knowing misrepresentation of the truth or concealment of material fact that any other person may act to his detriment, a suggestion as to a fact which is not true by one who does not believe it to be true, an active concealment of a fact by a person having knowledge of the fact, a promise made without intention of keeping it, a representation made in a reckless manner, whether it be true or false, any other act or omission specifically declares to be fraud. Now, this language is substantially borrowed from section 17 of the Contract Act. Lordship knows in section 17, a contract becomes voidable if there is either coercion, undue influence, fraud, or misrepresentation. 15 is coercion, 16 undue influence, 17 is fraud, 18 is misrepresentation. If any of these things happen, the contract becomes voidable. If a lordship sees fraud, I'm just speaking from memory, fraud in the Contract Act is basically 4 components. Suppressio veri, suppressing the truth, which is also mentioned here. Suggestio falsi, making a false suggestion. 3, any other act fitted to deceive. And 4th, making a promise without intention of keeping it. That is the 4 definition of fraud. And the explanation, the famous explanation is silence amounts to fraud if there is a duty to speak.
So your argument is?
Yes. No, all these.
So in accordance with the definition
Yes.
of fraud as provided in 2C,
Yes.
which includes an act,
Yes.
expression,
Yes.
omission, or concealment.
Concealment.
This act of creating 12 companies is a fraud.
It's a fraud.
That's your argument.
Yes. Yes. And concealing it.
What is that concealment?
They never told us. Only when we investigated, we found out these 12 companies are there.
They were expected to disclose to whom?
Clause 3.2 and 1.2.
No. The point is, if you're going to violate the position limits with these 12 companies, it is concealed. Nobody knew about it. Only when the investigation took place, we came to know about these companies.
Otherwise, they are obliged to disclose
No, they
to whom?
cannot, no, because they can't come and tell SEBI, I'm going to start 12 companies to do this. It's not allowed at all.
Right. So it's the act.
Yes.
According to you,
It's
the
an act.
Okay.
One is the act of creating 12 companies. Consciously violating the position limits. You are doing indirectly what you are not supposed to do. You're breaching. Yes.
Correct. So act.
Yes, my lord. Basically, what happens? The law says you can't cross 1% or 5%. You can't drive a coach and 4 through that by the device of 12 companies. So
Right.
12 companies is a colorable device, is an artifice to circumvent the clear position of law. Now, so there is act, concealment, and in a deceitful manner by R1 or with this connivance by agent, by the 12 agents. While dealing in securities, in order to induce another person or his agent to deal in securities, whether or not any gain. Now, my lord, in knowing misrepresentation or concealment of material fact in order that another person may act to his detriment, how does it happen? Let's take one. Now, my lord, if what happens is there is a cash segment where people buy and sell, and there is a derivative segment which is futures. You only take a position that this share will be, today it is 100, it will be 95 in 30 days or 60 days. That's selling short. I may take a position, go to 110, that is long. Now, the movement in the cash segment influences the derivative segment because both can't act in isolation. The one will influence the other. Suppose not suddenly, I'm told is how the, what's the phrase? Market, making market. Marking the market. Suppose, my lord, a large number of people are selling, say, Indian hotels short. All are taking short position. So market thinks that there is something wrong. The hotel industry may have some recession. So then the shares automatically get suppressed. So that also, so what happens is, now you have started 12 companies. None of the market knows that these 12 companies are nothing but RIL. You suddenly sell short. Your selling short goes to 62% of the market open position. So then market will wonder why is this going down. Surprisingly, here what happened to there, unfortunately, despite all this, the price started going up. That's why they had to sell all the shares in the last day 30 minutes, in the 7 minutes, yeah. So we're not knowing representation of truth. But no matter what I'm saying is, all these are factual points noted by the whole time member. We are given in our written submissions. Each and every point has been found by the whole time member. Now, second is suggestion as to a fact. Take C. Active concealment of a fact by a person having knowledge or belief of the fact. Completely concealment of this particular fact. And fraudulent shall be considered. Now, my lord, this is the definition of fraud. Correct. What the point is, concealment from whom? Suppose you announce it that, okay, we are going to have these futures. Here, it's a very paradoxical situation. You can't say, I'm going to violate the law, I'm starting 12 companies. So anyway, it is kept a secret. So I'm only trying to say, 2(1)(c) ingredients I have sought. There is an act, there is concealment, acting through agents is there, misrepresentation is there, and the other part, this what you call active concealment, knowing misrepresentation, and any act or omission which the law specifically declares to be fraudulent, deceptive behavior, yes, and shall be constituted fraudulent. Now, please come to regulation 3 and 4. The whole time member has found them guilty of 2(1)(c), of regulation 3, of regulation 4. 3 and 4. No.
4(1)(d). 4(2)(d). 4(2)(d) was dropped by the W. 4(2)(d).
Okay. Yes. My lord, I am told that 4(2)(d) was dropped by the whole time member. But let us come to 3 and 4. No person shall directly or indirectly buy, sell, otherwise deal in securities in a fraudulent manner, use or employ. Now, this is B is important, 3B. Use or employ in connection with issue, purchase, sale of any security listed or proposed to be listed, any manipulative or deceptive device or contrivance in contravention of the provisions of the Act or the rules and regulations made thereunder. The position limits is a regulation. Now kindly come to C. Employ any device, a scheme, artifice, defraud in connection dealing with securities which are listed or proposed to be listed. Engage in any practice which should operate as fraud or deceit upon any person in connection with dealing or issue of securities. Then 4, without prejudice to the provisions of Regulation 3, no person shall indulge in a fraudulent or unfair trade practice. 2, dealing in securities shall be deemed first is you shall not indulge in a fraudulent practice. 4.2 creates a legal fiction. Lordship sees that, Lord?
Yes.
4.2 creates a legal fiction.
Deemed to be fraudulent.
Deemed to be fraudulent or an unfair trade practice if it involves fraud and may include all other so and so. So I am saying that once it is a fraud in terms of 2(1)(c), then it deemed to be FUTP. Now, please see the examples given or the indulging in an act which creates false or misleading appearance of trading in the securities market, dealing in a security not intended to effect trans not relevant, advancing or against not relevant, paying or so and so, so and so. Now, and E, kindly come to E, any act or omission amounting to manipulation of the price of a security. What is that manipulation? Selling so many crores of shares in the last 30 minutes, 7 minutes, because Lordship knows the average price in the last 30 minutes in the cash segment will be the strike price for the derivatives market. But suppose I've taken a position of 142 rupees. And if the last 30 minutes average price is 145, then I've sold short, my loss is 3 rupees per share. Suppose the price goes to 137, I benefit. Lordship appreciates. So the average of the last 30 minutes trade in the Bombay Stock Exchange or the National Stock Exchange, that average price will be the strike price in the derivatives market. On that benchmark, my loss or profit has to be determined. Now, manipulation is suddenly dumping all these shares overnight in a short 7-minute span and billing the price in 7 minutes. The price came from 224 to 208. But in 7 minutes, a drop of 10% is huge. So my humble submission is, now these are all, I'm not arguing on the original side, but this all has been considered by the whole time member. The proposition I'm making to your Lordship is this. If your Lordship sees the written submissions given first and the written submissions given now, with great respect, my Lord, there is no discussion as to how the whole time members' finding of violation of Regulation 3 and 4, how it is a fraud, how it is faulty has not been mentioned at all. Similarly, SAT majority members and minority also accepts that there is violation. But as I pointed out at page 20, he says only thing is that 1 lakh penalty is the only violation. Violation of the position limits doesn't amount to PFUTP. I am requesting, that's not the view of the majority. Majority says yes. If you violate the position limits, you're not just violating SCRA circular, you're violating the PFUTP regulations, you're manipulating the market. And just see what will happen if the minority view is accepted. It will lead to complete chaos in the sense that anybody can do anything. I can just violate the position limits and sorry, I'll pay 1 lakh and I'll be done with it. That is not the, no need to disgorge me. Yes. So the submission I'm making is this, Murad. I've finished the statutory proof. I've now come to the case laws. The proposition of laws I'm taking are this, Murad. First, Murad is
Just. Yes.
But before your Lordship, I will just make one point I wanted to mention on facts before going to the case law. Now the defense taken is that this was a bona fide commercial hedging transaction. Hedging is a method where you mitigate your risk. It happens mainly in commodities where I have to buy a lot of raw materials which are subject to volatility. So I hedge my risk. Similarly, it's also hedging is very popular in forex transaction, foreign exchange, because the currencies may keep on fluctuating. So I have hedging in foreign exchange also. My first submission to Lordship is this. If it was hedging, then there would have been some board resolution, some decision taken that, look here, we have to raise so many thousand crores for our expansion. Part of the fundraising program is to sell 22 crore shares of Reliance Futures, Reliance Petrochemical. This may lead to some loss, and therefore let us enter into hedging. So hedging has to be done by some means of a resolution. What I'm submitting is hedging has become a complete afterthought. After they were caught and this was found, now how to justify it, they say hedging. I'm just trying to argue that if it was a hedge, there would have been some documentation, some resolution, some policy to say, we are going to raise 5,000, 10,000 crores to selling 22 crore shares we are going to sell. We anticipate volatility, so let us hedge it. Nothing on record. Nothing on record. And that's why even the finding is it's an afterthought, and it's not, the hedging is not an answer at all. Hedging is for management of risk. Hedging is not a profit-making tool. Here, what they have done is, right hand, left hand know what each other is doing. When I sell my shares, I know it's going to drop. So I create 12 companies, I'll sell short. In fact, if this market had not, because market behaves in strange ways, if on the last few days, if RPL shares had not gone up and up, the profit would have been much more than 500 crores because they would have sold short. So my humble submission is, first point I'm making is the theory of hedge has to be rejected because there is no document to show that the board took a decision for the need to hedge. When I'm not talking, it's not selling 5 lakh shares, selling 22 crore shares. And this could not have been done at a policy decision. So hedging is to be rejected because it's an afterthought. It was never hedging, number one. Pardon me? Our written submission. Yes. But I'll finish hedging. Page 26 of the written submissions, or my written submission.
Yes.
Yeah. But in fact, the excellent definition of hedging is by a full bench of the Gujarat High Court. Because Lordship knows, my lord, under the Income Tax Act, what is
Pankaj Oil Mill.
Pankaj Oil Mills, yes, Lordship knows, my lord. That is a speculative transaction under 43(5). So they distinguish hedging and this. If a Lordship, then I won't trouble Lordship with that judgment.
No.
Not necessary. Yeah. Now please see, my lord, page. And there's also Canadian Supreme Court judgment, which also says the same thing. Page 26.
Yes.
Yeah. Yes. Page 50.
Page 26.
Yes.
PDF 27.
Yes. Lordship will just come to page 53 on market manipulation, because the chapter heading is manipulation of market.
Yes.
So please come to para 53. I'm a humble submission. These are findings of fact. And unless they can be shown to be perverse or based on no evidence, my lord, Lordship's jurisdiction is a question of law. My humble submission is they should not be interfered with.
Okay.
Please come to para 53. The WTM order and majority view of SAT in view of the above mentioned circumstances therefore gave the following cogent findings to establish.
Where are you reading?
I'm so sorry, my lord. Page 25 of my written submission.
Para 53.
Para 53, correct.
Yes.
The whole time WTM order and majority view of SAT in view of the above mentioned circumstances therefore gave the following cogent findings to establish that RIL perpetrated a scheme of market manipulation. RIL selected the last 10 minutes of trading on 29th November and also day of expiry of November 27 future to get advantage of the closing price in the cash segment, which would immediately convert into returns in the future segment. Now that's that average will be The unseemly hurry to press ahead with large sales in the last 10 minutes when there was no deadline was entirely motivated by the objective to fraudulently push the price down. This is very important. But Reliance had to raise money by selling RPL shares. There was no thing that you must sell it on or before 30th November because the resolution was passed in March. There was no timeline that, look, by 30th November, I must raise the money. That's what the whole time I was saying. The cash segment during the last 10 minutes is fraudulent and manipulative in nature. So these are the findings, my lord, of the whole time member and affirmed by the majority. Now please come to hedging. In order to justify transactions in the F&O segment, RIL contended that such transaction nature of hedging transactions.
These are your written submissions.
Yes.
We'll look into it.
Very.
Let's see the case law you propose to rely on.
Yes. Now, my lord, one case law. I'll start off with what is the jurisdiction of this court, and that is in SEBI versus Mega Corporation, and that is in my case law compilation. That is, you got a hard copy or soft copy? Hard copy. Lordship has got the hard copy or soft copy? No? Case law compilation.
Case law, we will have hard copy also. Yes.
Page 484 is the judgment starts.
484.
484.
Ah.
2023 12 SCC 802.
Hmm.
And if my lord comes to para 20,
Yes.
yes. But actually para 18, this, but we had this question of law in section 256 of the Income Tax Act, then it became substantial question of law. Now kindly come to in the context of SEBI para 20 at page 495.
Ah. Ah.
The jurisdiction of the Supreme Court under section 15Z is to consider any question of law arising from the orders of tribunal should therefore be seen in the context of the powers and jurisdiction of the tribunal under 15K, 15L, 15M, 15T, 15U and 15Y. Lordship will just circle 15T because the appeal to SEBI lies under 15 capital T, appeal to SAT. And Supreme Court is 15Z. It is in the functioning of the tribunal to re-examine all questions of fact at the appellate stage while exercising jurisdiction under 15T of the Act. In Clariant and National Securities Depository Limited, this court had an occasion to examine the jurisdiction of the tribunal and explain that the tribunal has wide powers. Being a permanent body, apart from acting as an appellate tribunal on facts, the tribunal routinely interprets the Act, rules and regulations made thereunder and evolves a legal regime systematically developed over a period of time. The advantage and benefit of this process is consistency and structural evolution of sectorial laws. The 21 is important. It is in the above referred context that the Supreme Court, while exercising appellate jurisdiction under 15Z of the Act, would be measured in its approach while entertaining any appeal from the decision of the tribunal. This freedom to evolve and interpret laws must belong to tribunals to subserve the regulatory regime for clarity and consistency, and is with this perspective that the Supreme Court will consider appeals against judgments of tribunals on questions of law arising on so and so, so and so. Then 23, my lord. The scope of appeal under 15Z may be formulated as under 23.1. The Supreme Court will exercise jurisdiction only when there is a question of law arising for consideration to the tribunal. A question of law may arise when there is an erroneous construction of the legal provisions of the statute or the legal principles of law. In such cases, the Supreme Court, in exercise of its jurisdiction of 15Z, may substitute its decision on any question of law it considers appropriate. My humble submission, my lord, that the construction of regulation 21C, 3 and 4 of the PFUTP regulations, the construction of the position limits, both by the whole time member and the tribunal, is correct. There is nothing erroneous and does not lead to any question of law, is our humble submission. Then 23.2. However, not every interpretation of the law would amount to a question of law warranting exercise of jurisdiction under 15Z. The tribunal exercising jurisdiction under 15T, apart from acting as an appellate authority, also interprets all facts, also interprets the act, rules and regulations made thereunder, and systematically evolves a legal regime. These very principles are applied consistently for structural evolution of the sectorial laws. This freedom to evolve and interpret laws must belong to the tribunal to subserve the regulatory regime for clarity and consistency. These are policy and functional considerations which the Supreme Court will bear in mind while exercising jurisdiction and so and so. But I would submit, my lord, of course, your lordship has to interpret, it has to interpret. But what I'm submitting is what the whole time member has done and what the majority has followed is a consistent pattern of interpreting regulation 3 and 4. What is manipulation? What is inducement? This concept of 12 companies, there's a concept in SEBI law called acting in concert. If you find people are acting in concert, then you can lift the wheel, so to speak, and find out who is the person behind it. And then you can take. So without taking your lordship's time, no judgment has been shown to your lordship to show that, look, this interpretation by the SAT is inconsistent with an earlier view, is contrary to a Supreme Court judgment. Nothing has been shown. The short point is, I violated SCRA, impose 1 lakh and that's all, which in my humble submission is not a correct reading of the thing.
Okay.
No. So this is on the mini question of law. Now, on this question of inducement, the leading case is Rakhi trading, page 347. And my lord, the operative portions are at page 77 to page 396. But this is important because it directly deals with regulation 3 and 4 and 4.2a. So it is very close to our case. May I read 77 at page
Yes.
396? Regulation 3 deals with prohibition of certain dealings in securities. Regulation 4 deals with prohibition of manipulative, fraudulent, unfair trade practice. Regulation 4 starts with unfair prejudice to the provision of Regulation 3. Regulation 4.2 is an inclusive provision. 4.2 stipulates that dealing in security shall be deemed to be a fraudulent or an unfair trade practice, if so and so, so and so. But I'll skip all that. An act to fall within 4.2a, very important. It is not necessary that the transactions were entered into with the party which manipulate the market and that the market was in fact manipulated. Market manipulation is a deliberate attempt to interfere with the free and fair operation of the market and create artificial, false, or misleading appearances with respect to price, market, product, security, and currency. Respondent Rakhi trading and Kasam holding on facts are found to have engaged in non-genuine transactions, creating appearance of trading. If the factum of manipulation is established, it will necessarily follow that the investors in the market have been induced to buy or sell and that no further proof in this regard required. The market outwardly observed is so widespread that it may not be humanly possible for the board to track the persons who are actually induced to buy or sell securities as a result of manipulation, and the board cannot be imposed the burden which is impossible to be discharged. And Rakhi trading has been followed again and again and again, that all that SEBI has to establish is that there was manipulation or a fraudulent practice, then that inducement is a logical sequitur. That's Rakhi trading. Now, next is Kanhaiya Baldev, 316.
Yes.
Para 54, page para 53 and 54 at page 344. Lord, both Kanhaiya Lal and Rakhi have been followed in a number of cases.
Yes.
Regulation 53. If Regulation 2(1)(c) of the 2000 regulations was to be dissected and analyzed, it is clear that any act, expression, omission, or concealment whether in a deceitful manner or not, by any person while dealing with securities, to induce another person to deal in securities would amount to a fraudulent act. The emphasis in the definition of Regulation 21C is not, therefore, whether the act, expression, omission, or concealment has been committed in a deceitful manner, but whether such act, expression, omission, or concealment has/had the effect of inducing another person to deal in securities. The definition of fraud, which is an inclusive definition and therefore to be understood to be broad and expansive, and contemplates even an act or omission has been committed, even without any deceit, if such act or omission has the effect of inducing another person to deal in securities. Certainly, the definition expands beyond what can normally be understood to be a fraudulent act or a conduct amounting to fraud. The emphasis is on the act of inducement, and the scrutiny will therefore be on the meaning attributed to the word induced. Then they discuss what is induced. Para 56. Now, this is in 2017. In 2018, Rakhi Trading goes one step further and says, once there's market manipulation, inducement is automatic. So, should I read inducement? Lordship will just make a note, not. Then last, Kishore Ajmera. What's Kishore Ajmera? What Kishore Ajmera? Yeah. Well, at Kishore Ajmera, I'll just mention the proposition. It says that a test is preponderance of probability. In my humble submission, in this case, there's no probability. It's actual fact we have established. 12 companies have entered into a thing, control 93% on the last dates. I won't want to repeat all the facts. So this goes one step beyond preponderance of probabilities. What do you want to show? In Kishore Ajmera? All right. Para 25 in Kishore Ajmera. Lordship will just make a note of it.
Yes.
Yes. Now, para 25 mentions about the SEBI's act and objects. 26 I'll straight away go to. It is a fundamental principle of law that proof of an allegation leveled against a person may be in the form of direct substantive evidence, or in many cases, such proof may have to be inferred by a logical process of reasoning from the totality of attending facts and circumstances surrounding the allegations, charges made and leveled. While direct evidence is a more certain basis to come to a conclusion, yet in the absence thereof, the courts cannot be helpless. It's a judicial duty to take note of the immediate and proximate facts and circumstances surrounding the event on which charges, allegations are founded, and to reach what would appear to the court to be a reasonable conclusion therefrom. The test would always be what inferential process that a reasonable, prudent man would adopt to arrive at a conclusion. But my humble submission, the facts clearly establish manipulative and fraudulent practices. 31. Yes, para 31 at this important. At page 314. The conclusion has to be gathered from various circumstances like volume of trade, period of persistence in trading, particulars of buy and sell order, namely volume thereof, the proximity of time between the two and such other relevant factors, the fact that the broker himself has initiated the sale of a particular quantity of scrip on a particular day, and at the end of the day, approximately equal number of shares come back to him, that trading has gone without settlement of accounts, without any payment, and the volume of trading of the illiquid scrip, all should raise a serious doubt in a reasonable man as to whether trades were genuine. The failure of the brokers to alert themselves to the minimum requirement and their persistence in trading in the particular scrip over a long period of time, or in respect of huge volume in our considered view, would only disclose negligence or lack of care and caution, but would demonstrate deliberate intention to indulge in trading beyond the forbidden limits, thereby attracting the provisions of PFUTP regulations. Therefore, my lord, what this judgment says is, if you trade beyond the prescribed limits, then you attract PFUTP regulations. And all these questions of volume, etc. are satisfied. All right.
That's it. One more time you stand up and then we'll have to.
No. But they always think
You have harassed Mr. Datar like anything.
No, but actually he has done most of the work.
Of course.
No. They always feel the senior has not fully understood the case.
Has he missed something?
No, he wanted to give a judgment of Shriram Mutual Fund, which says that once the things are established, penalty follows. And what now, my lord, there is second appeal. You're right. But there is one more appeal. But SEBI has got a very peculiar thing. There is a whole-time member who does the who does the civil matter and imposes disgorgement. Then there is a or debarment. Disgorgement, yes. There is another member, what's called the AO, adjudicating officer, who goes and imposes penalty in that 15x15, those are penal provisions. In this case, my lord, there was a penalty also imposed by the AO. Following the WTM order, he said, I'm imposing penalty. 2 appeals were filed by Reliance. One was on this disgorgement, one was on penalty. What the SAT says in the penalty order is, in view of our judgment in that, penalty is followed. So that appeal also has to be dismissed as our submission. So anything else?
Thank you. Arguments concluded, judgment
My
reserved.
Lord, we would like to rejoin on 14th. Very short submissions. At least, well, this was what was understood earlier. I have apologized.
But today it was kept because a request was made. You want?
My understanding was that Mr. Datar will complete today and Mr. Salve on a rejoinder afterwards. There are certain submissions we'd like to certainly rejoin. I'm please requesting if we can be accommodated.
On which date?
Friday 14th, I believe 7th, the bench is not available Friday.
14th. 14th of?
November.
Then we would not have kept the matter today. We would have kept it on 14th only.
We were under the impression Mr. Datar will complete today and we will rejoin thereafter because Mr. Salve was not available today. I'm sincerely requesting if that can be accommodated. Very short, we'll keep it very short, but on 14th.
My goodness.
The limited submission.
चलो 14th पे रख दो. इसको बांध दो.
I'm deeply grateful.
14th at 2 p.m.
Enough, right? What's the rejoinder? No sir rejoinder. My friend is saying sir rejoinder. I said no.
Then penalty also to you and PUTP also and everything. Mr. Datar, the learned senior counsel appearing for SEBI, has concluded his submissions. There's a request made that Mr. Salve, the learned senior counsel, would like to submit something in rejoinder. Right? Post it on 14th. 14th is a Friday. 14th at 2 p.m. Okay. Okay. Just. That's it. Thank you. Thank you.